Good morning, everyone. We are in the Indigenous and Northern Affairs Standing Committee of Canada, and we are studying Bill C-92, and we have the privilege of having video conference participation as well as in-house representatives of various groups and individuals. So before we start, we always recognize that we are on the unceded territory of the Algonquin people here, and in a hope that all Canadians start to consider where they're from, what the history of their region is, and to participate actively in reconciliation. So, let's get started. The way the process works is that every presenter, and sometimes you split your time, will get up to 10 minutes. I'll give you signals as you get close, and after all presentations are done, which will be in 30 minutes, we go through Q&A from members of the committee. All right, not to take any more time away from you, we will begin with the women of the Métis Nation, Melanie Omeno. Maybe I pronounced that wrong. I'm sorry, Melanie. But it's your turn to start, and you can correct me. Thank you.
Thank you. Good morning, everybody. My name is actually Melanie Omenhio, and I'm the president of La Femme Michif Otipimsewak, Women of the Métis Nation. And I want to identify before we get going that La Femme Michif Otipimsewak is not the French version of Women of the Métis Nation. It actually is a Michif name that was given to us by our elders, and it means the Métis women who own themselves. So LFMO is a recognized voice of the Métis women from across the Métis homeland. We operate in a democratic, transparent, and a fiscally accountable manner. We work to try to influence public policy and decision-making related to concerns and aspirations of Métis women at all levels of Indigenous and Canadian government. LFMO's views on Bill C-92 as a step forward, we are looking at it as a step forward draft at best. It falls short of accomplishing its goals to shift child and family services from a system of apprehension to a system built around preventative and family supportive care. This is another example of pan-Indigenous approach to system change that does not acknowledge the distinctions between First Nations, Métis, and Inuit people. It does not acknowledge the unique distinctions of each of the Indigenous people of Canada, and that a one-size-fits-all approach has been a failure in the past. It is important to acknowledge the impacts of colonization has had from a distinct perspective. This bill also misses the mark in transferring full and complete jurisdiction of child and family services. Although highlighted in the principle on substantive equality, 3B reads that a child must be able to exercise his or her rights under the Act, including the right to have his or her views and preferences considered in decisions that affect him or her, and he or she must be able to do so without discrimination, including discrimination based on sex or gender identity or expression. We find this section is contradictory from a gendered lens, as the entire incorporated a very gender use of the terms he and she, or him and her, instead of they and them. LFMO recommends that the language be amended to reflect the principles of these issues so that it is a gender-friendly document. LFMO believes that the principle in the best interest of the child must be defined. It is not specific enough to counteract the impact of the dominant culture on Indigenous children and families. 9.1 is set out and prioritizes the best interests of the child. This principle, as defined, could lead to further marginalization and does not protect children and families who are in poor socioeconomic situations. It is known that the poverty experienced is a result of colonization. We have seen that using Western concepts of well-being when considering Indigenous children causes increased involvement with child and family services and leads to apprehension of Indigenous children. LFMO recommends that this principle be clearly defined as to what is the best interest means, and that 3 principles defined are given equal weighting. It's been far too long that fostering a child is not motivated on altruistic goals. To some, this is a paycheck. Our children are not an object of commerce in the child and family services economy, and every effort should be exhausted to ensure that care providers are assessed to ensure that this is not the primary motivation. Where this is of specific note is in Section 13, where representatives and party status is granted to care providers. As care providers are paid for their work with the child, is counterproductive and harmful to the child that these entities are giving standing in consideration of the well-being of the child. LFMO recommends that care providers are excluded from representation and standing to ensure that the child's interests are primary and not the socioeconomic gain of a care provider. LFMO recommends that dispute resolution mechanism is defined. In the event that provinces and an Indigenous governing body cannot enter into coordination agreements, without further definition of dispute resolution process will most likely align with the federal or provincial government approaches rather than an Indigenous model of dispute resolution. Mechanisms must be in place to provide for binding decisions. The main concern of Bill C-92 from a Métis women's perspective is that it is presented without definition of funding pathways to ensure full participation by Indigenous nations. With no predictable funding, the principle of substantive equality as defined in the Act is a moot point. We cannot fully participate unless we are fully resourced to do so. This will impede our involvement with Indigenous children and youth from beginning to exiting the child welfare systems. La Femme Michifo-Tepimswak offers the following recommendations to be included in Bill C-92. That a distinctions-based approach be applied to the Act. That prevention and early intervention be the model of care rather than apprehension. That the Métis Nation and La Femme Michifo-Tepimswak be provided with predictable funding to ensure adequate infrastructure is in place to respond to the needs of our Métis children. That Métis children in care are identified as Métis and not as other Indigenous. That resources be allotted to ensure full wraparound services for Métis children. That the age of youth in care be extended to 21 years old so that our children do not fall into other systems such as the justice system, and that Métis data collection and research models be resourced to ensure that funding reflects the magnitude of the number of children in care. Thank you.
Thank you very much. Very insightful, and we're looking forward to Naomi and Hedley Freeland, who are sharing time, and however you want to do that, please go ahead. Okay.
Good morning. So you know that we are 2 of the authors of the Yellowhead report card on Bill C-92. I believe you've been provided that report, and you know that we found significant problems in our report. That said, we do believe that the legislation has good spirit and intent behind it, but there are some key improvements that we believe must be made in order for it to be effective. We're going to split our time. What I am going to focus on is why we believe it is so important for the bill to address funding and accountability. And this is really intertwined with jurisdiction because really if there is no funding and accountability built into this act, what this bill will do is merely provide Indigenous people with the jurisdiction to legislate over their own poverty. I've seen the black line version that Cindy Blackstock has been circulating, and I believe members of this committee have a copy of that. And I do believe that what is proposed in the suggested amendments on funding and accountability are workable solutions. We really believe that this bill is an opportunity to make a difference in such an important area. It has been said by many, including the TRC and the Canadian Human Rights Tribunal, that the child welfare system is today's modern incarnation of the residential school system. So you as lawmakers have a really historic opportunity before you to do something perhaps that previous parliamentarians didn't do or couldn't do. So I urge you to do this right. Because if you don't, then and you produce something that is just a hollow gesture, then that's not sufficient for Indigenous children. A lot of my writing as an academic has been on how child welfare is a very problematic area in terms of how it is structured with respect to First Nations issues. It suffers from major systemic problems and structural design problems. I have a very long paper on it if you want to read it, but just to give you the high points of it, it's a system that's been in place for almost about 70 years, and the sort of key features of it are jurisdictional neglect, meaning that neither the federal government nor the provincial governments have ever really wanted primary jurisdiction in this area. Both argues that the other is accountable to provide services in this area, and Indigenous issues and First Nations issues become a jurisdictional hot potato, which leaves Indigenous kids in a vacuum and creates risks and uncertainty, and that's in nobody's interest. This system has also allowed underfunding to continue knowingly for over a decade, by Department of Indigenous Affairs officials, while at the same time going unnoticed by parliamentarians more broadly and Canadian society more broadly. The system as it's currently structured really doesn't provide the oversight and accountability, and we desperately need it. The system, the way it has been structured, also creates a terrible power imbalance where First Nations have really very little means to challenge this system and to hold officials accountable. But for Cindy Blackstock and the AFN bringing their case forward, we wouldn't be here. So it's so important to remember that case. And really the case is a real watershed for a couple of major reasons. One, because it found that not only were Indigenous services underfunded, but Indigenous people are entitled to funding and services that meet their needs and circumstances, just like all other Canadians. And it also, the decision is very clear that it confirms that it is the responsibility of the federal government under Section 9124 to provide these services and funding. So with that said, I am a proponent of the federal government legislating in this area, but it cannot just be about recognizing jurisdiction alone. That is a necessary part, but it is not sufficient on its own. The law also needs to put in funding mechanisms and accountability measures. And funding should not be made contingent on First Nations and other Indigenous groups reaching agreement with provincial governments. Really, the buck should stop with the federal government. If the federal government feels that the provinces should be kicking in some money as well in this, then leave that to the feds and the provinces to negotiate. Do not put it on the backs of Indigenous people who have historically faced a massive power imbalance to have to try to negotiate themselves, because it's not going to work and we're just going to be left legislating our own poverty. And really, that sort of approach, leaving it to the feds and provinces to work out if they want to share money, is consistent with Jordan's principle. I echo the sentiments about, because I'm running short on time, that there does need to be an independent decision-making body with the ability to make binding decisions in terms of accountability. And the proposal I've seen is to allow the Canadian Human Rights Commission as a last resort to be the body to do that, and I believe that that makes a lot of sense. Although I do encourage there to be dispute resolution mechanisms built within the system. Finally, I'll just say that I do believe that, consistent with call to action number 2, that there needs to be mandatory data collection and publication as part of this, as part of the accountability measures that are built into this bill. Thank you. Hand it to my friend. Sorry.
And I'll pick up on talking about in the national standards that issue of best interests of the child, and I'll also talk about jurisdiction and so some suggestions for strengthening this bill so its intent is actually met. So best interests of the child, we firmly believe that without some strong mandatory language to address bias and to clearly overtake binding precedent, this bill could easily maintain the status quo. And nobody is saying that best interests of the child, the idea that the child should be at the center and the child's needs are the most important, that there's anything wrong with that. I think everybody's in agreement with that. It's how it's been interpreted and it's how it's been applied by courts that has been detrimental to Indigenous children. So there's 2 legal issues. The first legal issue for best interests of the child leading to overrepresentation is that almost all provincial statutes have mandatory timelines, where after a certain amount of time in care, a child all their legal relationships with their family, an extended family, will be severed permanently based on time, regardless of what's in their best interest. And the second is a 1983 Supreme Court case called Racine and Woods that is still good law. It's still binding precedent, as in lower courts must apply it to a case before them. And this links the concept of best interests of the child to a troublesome notion that the importance of cultural background and heritage fades in time while the importance of bonding increases. This was from 36 years ago. Attachment theory has vastly improved since experts weighed in. We have the case Brown in Canada, the 60 Scoop case, which points out from experts across the country that the absence of being connected to that cultural heritage caused great harm. And we also have a very different landscape in family law. We have children living in joint custody situations. We have contact orders. We have a lot more tools. And we know that children grow up in a variety of family structures and do very well as adults. So we've moved past this, but the law with Racine and Woods has not. So some suggestions for adding or amending to address this issue. Consider an impermissible reasoning clause. So when determining the best interests of the child, it would be impermissible to say the length of an Indigenous child's time out of parental care or in the care of a specific caregiver is sufficient reason in itself to say it's in the best interests of the child to sever relationships or grant permanency. Consider an active efforts principle, like in the American Act that deals with Indigenous child welfare, that encourages that preventative care and requires decision makers to say what steps have been done in the best interests of the child before removal. And consider removing where best interests of the child is unnecessary. So Section 23, subjecting Indigenous laws to best interests of the child, either being very specific if that's about immediate physical safety, immediate physical safety as opposed to best interests. And keep in mind that the courts will retain their parents patriae jurisdiction. Courts can always weigh in on laws that they think are not in the best interests of the child. Turning quickly to jurisdiction, this is a huge positive step forward to acknowledge the inherent jurisdiction in this area. What we're recommending is certainty and clarity. So clarity in defining federal and provincial jurisdiction, as my colleague said. Clarity in conflicts. Paramountcy rules need to be clear enough that a frontline social worker dealing with a crisis understands what the law requires of them. Certainty of access to Indigenous laws. addressing whether this jurisdiction is reserved to geographical areas like on reserve, or if it follows Indigenous citizens where they go, where Indigenous children go. So including off-reserve First Nations children, Métis children, Inuit children, non-status children, making sure they also have access to Indigenous laws. And finally, it comes back to my colleague's point, certainty of funding, ensuring that this is not a hollow promise, because without the resources to implement, develop, implement, and deliver on Indigenous laws, the jurisdiction is going to remain hollow. Thank you.
Thank you very much. Dwight, you've been very patient. Thank you for doing so. Dwight Newman, Professor of Law, Canada Research Chair in Indigenous Rights. Welcome to our committee. We look forward to your comments, and you can start whenever you're ready. 10 minutes.
Okay. Well, good morning. As mentioned, my name is Dwight Newman, and I'm a Professor of Law and Canada Research Chair in Indigenous Rights in Constitutional and International Law at the University of Saskatchewan. I've done writing on various topics in Indigenous rights law. I also write on general constitutional law topics, and on the latter writing, I'm the author on the Halsbury's Laws of Canada volume on the Charter of Rights, and along with Ottawa practitioner Guy Regenbeld, I co-author a 1,000-page constitutional treatise, The Law of the Canadian Constitution, published by LexisNexis, and now in its second edition. Although we're discussing a bill profoundly important to addressing ongoing harms against Indigenous children and Indigenous communities, my comments today will be on some more general constitutional considerations related to the bill. And in short, I think there are some issues with the constitutionality of significant parts of the bill, and that the committee should be adducing further evidence on these matters and quite possibly amending parts of the bill. While the Minister tabled the now standard charter statement on the bill in the House of Commons on April 29th, there are constitutional considerations going beyond the charter that deserve further attention here. Obviously, in addition to the Section 35 issues. And in particular, the bill involves an extremely muscular assertion of federal jurisdiction in areas that have traditionally been under provincial jurisdiction. And in my view, it appears to do so in ways that go beyond the scope of federal jurisdiction in at least parts of the bill. So let me be clear from the outset. Everyone knows that jurisdictional quagmires have been problematic in getting to good ways forward in this area. And we need to find ways past those, and the references by earlier witnesses to the jurisdictional hot potatoes are a horrible Canadian legacy. We could talk about the horrible funding disputes that gave rise to the need for Jordan's Principle and that give rise to ongoing problems, and there's every reason why division of powers between the federal and provincial governments isn't necessarily what people want to think about when trying to come up with solutions, other than to find ways past those. At the same time, federal legislation still can't unilaterally operate in ways that set out to legislate in areas of provincial jurisdiction. The Supreme Court of Canada has identified federalism as one of the 4 key constitutional principles defining the structure of the Canadian Constitution. Canada is a federation, not a unitary state, and it's vital to maintain respect for federalism pursuant to the established powers in the Constitution. Section 7 of the bill sets matters off on a problematic track, stating that this act is binding on Her Majesty in right of Canada or of a province. From the outset, we see a claim to legislate concerning the activities of the executive arms of the provincial governments that's inconsistent with principles of federalism. So I feel like I'm offering an 8:30 a.m. Division of Powers seminar there and a 6:30 a.m. Division of Powers seminar here via video, which is not a popular option with students or with anyone else. But I want to quickly set out the pertinent claims to jurisdiction as they apply to the rest of the bill. Under Section 92 powers in the Constitution Act 1867, in Sections 92.13 and 92.16, The provinces have wide powers over matters of private law and matters of local concern, which have always grounded in general a provincial jurisdiction to deal with child welfare matters. That was extended to on-reserve jurisdiction, the application of provincial jurisdiction on reserve, by Section 88 of the federal government's Indian Act, which gives power to provincial legislative provisions to apply even on reserve. The federal government has in Section 9124 of the Constitution Act 1867 a power that I emphasize is in the language of 1867, and I always put in scare quotes over Indians and lands reserved for the Indians. Subsequent case law has made clear that this power extends in relation to fundamental governmental relationships with all Aboriginal peoples of Canada, First Nations, Métis, and Inuit, as in Section 35 of the Constitution Act 1982. One challenging dimension is that Section 9124 and the scope of the federal power hasn't been well defined in case law in general. Leave aside the child welfare context, but just in general. The case law has seen Section 9124 invoked more to say what provinces can't do than what the federal government can. So there are real questions on how far 9124 extends, but they have to be understood in the context of the rest of the powers in 91 and 92. The scope of the federal 9124 power would, in my view, certainly extend to matters of governmental relations with Indigenous governing authorities. And I would see it as having lots of potential to support provisions in the bill like sections 20 through 24 that essentially recognize the legal power of Indigenous groups, communities, and governments and governing authorities. Even there, though, I might flag section 22 sub 3 as warranting some discussion on whether the federal government can cause every law of an Indigenous group to prevail over provincial law in every instance. It's one of these paramountcy or conflict clauses, and I agree entirely with the point made earlier that there needs to be certainty in the law, and the context is the frontline social worker that needs to know what the law is, obviously. But there needs to be a law that fits with the division of powers, and 22.3, I think there may be some issues there. Even more significantly, sections 10 through 17 give rise to some significant division of powers questions. As set out in the bill in its present form, they would seem to be framed in a way that applies even to provincial child welfare decisions off reserve and outside the scope of any Indigenous governing authority as soon as an Indigenous child is involved. They simply regulate concerning every Indigenous child in more far-reaching ways. They contain many good principles. The spirit and aims of the bill are all very important, but there are serious questions on if the federal government has the constitutional authority to unilaterally enact some of these sections of the bill. So if the bill continues in something like its present form, I would recommend amending Section 7 of the bill to make it binding only on the federal crown. And I would recommend further review of division of powers questions on sections 10 through 17, as well as 22 sub 3, maybe others, but those are some that I would highlight. I would suggest ascertaining further advice from Justice Canada on these matters while subjecting their views to critical scrutiny to see if there's a solid 9124 basis for these provisions. I would quite possibly recommend amending the application of sections 10 through 17 to be triggered by agreement with each province. I would hope there would be goodwill with the provinces to develop good implementation here. If there's a division of powers issue there, the unilateral assertion of federal jurisdiction isn't going to further cooperation with the provinces, and it may subject the bill to ongoing constitutional challenges that mire the bill down rather than moving forward in supporting the futures of Indigenous children and in supporting reconciliation. There are tough matters here. Unfortunately, there aren't easy answers. and there aren't easy ways forward. But those would be a few reflections on some things to think about further in the bill, along with the excellent comments that we heard from other witnesses this morning.
Well, thank you very much. Our questioning period begins with MP Yves Robillard. If you're not fluent in French, take your earpiece and be sure that it's working.
Functioning? Oui.
Ready to go.
OK. Merci à vous.
Thank you all for your statements. My first questions will be for Ms. Metalik. On Tuesday, during our last meeting, Dory Sargent from the Department of Justice explained that this law was innovative. This law is one of the first to recognize Section 35 rights pursuant to the Constitution, rights for Indigenous people. Could you please give us more details about the constitutional legality of delegating jurisdiction over treatment of Indigenous peoples to the communities themselves? Yes, of course. I'm going to gather my thoughts. You'd like to hear about jurisprudence that would give you the sense that it is feasible to recognize the authority of Indigenous peoples. Well, a few examples. First, the report from 96 of the Commission on Indigenous Peoples' Rights. That report acknowledged that Section 35 guarantees the right to self-government. There's also the United Nations Declaration, which recognizes Indigenous rights, and the government will pass legislation based on the declaration, which speaks to self-government. And since 1996, there have been self-government agreements with Indigenous groups. There are many such agreements with Indigenous peoples all over Canada. And there have been rulings in British Columbia, though they haven't gotten all the way to the Supreme Court, but there have been judgments of constitutional validity. For example, Campbell versus British Columbia and the Chief Mountain case. And I'd be happy to give you more documentation. Those two judgments held that governmental autonomy is absolutely constitutional. Question. C-92 has a lot in common with the Indian Child Welfare Act enacted in the United States in the U.S. in 1978. Terry Liebesman, who wrote a book about Indigenous child welfare and comparative perspectives, according to him, in the United States, a lot of progress has been made in including Indigenous peoples and helping their children. Could you speak to similarities between C-92 and the American approach? My colleague will answer this question. She's more well-versed in the matter.
A few of the things that have been brought here, recognizing that inherent jurisdiction is similar to the Indian Child Welfare Act. The placement priority in this act is similar to the Indian Child Welfare Act. They also have a placement priority. I do think there is stronger language in in the Indian Child Welfare Act in the U.S. that is missing in Bill C-92. For example, they have a reasonable and active effort section saying that active efforts need to be taken before removing a child or not placing with family, and that's an example where Bill C-92 isn't as strong as.
Le ministre, pour Madame Oman-Neo, le ministre.
Question for Ms. Oman. Minister O'Regan told us about the co-development of this law and that there had been over 100 meetings all over the country. He spoke about sensitive issues and even skepticism that this bill would become law. Could you speak to us about how Métis communities feel about this law? Do you feel that the consultation process for this law is a step in the right direction?
First off, there was a considerable amount of consultation that was done in relationship to the building of this law. I want to tell you that I don't know that I would have defined it as co-developed. I'm going to be sincere about that. We didn't even see the act that was being brought forward, the final draft of the act. We weren't allowed to see that. So we were last to reviewed a previous draft, and co-development to me would be that we were actually working to develop it together, but really we were responding to what the Justice Department put forward in the act. It wasn't us coming up with the pieces of the act. So we did our best to have as much influence and engagement on those pieces as we could. We did so we are hopeful that this is at least looking and putting a light on an issue that's been a long-term problem for Métis children and Métis families. And we are hopeful that with the work that your committee and others are doing on this legislation, that we will have a piece of legislation that will assist us in ensuring that we change the road on where Métis children and Métis families have been so negatively impacted and affected. Just to even put it this way, we've had many children die in care, and many of our children, especially as the Métis, because the issues around whose jurisdiction we fall under has only recently been coming to the forefront. We've had children identified as unknown Aboriginal, so that they've fallen within the cracks of these systems. They haven't been addressed, and in some instances, I'm going to tell you that we know, I've worked with families whose children have died in care, and they haven't even been told till months later, and they're never told why those children died. This legislation is going to help us change some of that. It's going to help make accountability come into play, especially if we address some of the issues of who's going to financially resource some of this stuff. Thank you.
Merci beaucoup.
Thank you. Question now moves to MP Kathy McLeod.
Thank you. Excuse me. Thank you to all the witnesses for very compelling testimony. And I think you will see from all parliamentarians, we understand there's a very tragic situation that's gone on for far too long, and we need to find ways to address it. So as we look at this bill, what we really are trying to do is make it right. So I think we're all coming from a good place. It's just, where is this bill going to end up? Because it's very complex and complicated, and to be quite frank, I think it's going to be rushed in many ways. And, you know, I take note of Mr. Newman's comments, and, you know, we did have the Department of Justice, but I think there was sort of a grand total of 5 minutes to question her. So I just want to take a quote from her, and she said, "The legislation certainly recognizes an area of jurisdiction in relation to Indigenous governments, essentially government governing bodies, Section 35 rights, and it's founded in 9124 on a basis of federal jurisdiction." And she did also indicate that it is novel that both 91 and 92 are the first times where legislatively we've sought to define these rights. My first question, Mr. Newman, is that we quickly scan through this bill. You talk about amendments to the Indian Act, which gave jurisdiction on reserve to the provinces. I don't see anything in this bill that sort of takes that away. So is that going to be in conflict with this particular piece of legislation? I guess that's, if there's something in the Indian Act that defines that, I think, which I believe you indicated in your testimony, that might be a problem with this legislation. Is that accurate? Oh, can't hear you, sorry.
Sorry. Excuse me, we have to hold your comments. We have a technical problem. Can you speak again and see if we can pick you up? We could not hear you.
Okay, can you hear me now?
Yes. Please start from the beginning. Okay.
Sure. So in my quick comments, I couldn't explain Section 88 of the Indian Act in full, and to explain it in full would take a couple of hour-long classes. But basically, it just provides for the general application of provincial laws of general character on reserve, subject to a number of exceptions. And if this bill were to pass, one of those exceptions would end up kicking in. So there wouldn't be a problem arising in relation to Section 88 of the Indian Act per se. The broader issue is just that provinces have traditionally exercised child welfare jurisdiction, and this bill interferes off reserve there.
Okay, so I appreciate that, because I think that sort of twigged a concern. With the Indigenous language bill, I think for Parliament to, in consultation and collaboration with Indigenous peoples, to recognize some Section 35 rights rather than court systems is perfectly appropriate. And I think language was cleaner in terms of not having those provincial issues. So I think what we did with C91, although unique and unusual, is a little bit different than what's happening with 92. So for my interpretation of 92, if an organization, so for example, in the riding I represent, there is an agreement where there is an Indigenous organization providing services on and off reserve, and that is well agreed to. As I understand this piece of legislation, when those agreements are made, that makes sense. But in the absence of those agreements, you could potentially have off reserve. You could have someone that's, defined under the Daniels decision with sort of no particular group that is taken on a devolution of the authority under this act. And so what we are doing is we are imposing this legislation on the provinces without, for when they are taking care of off-reserve Indigenous children, without any conversation. As I understand it, that is your particular area of concern, is the constitutionality of doing that?
Yes. So in a number of sections of the bill, the bill makes statements regarding principles that apply in off-reserve child welfare contexts that would normally have been within the jurisdiction of the provinces, and it's not clear to me that they're within the 91-24 powers. So that's sections 10 through 17. The issue with the delegation through Indigenous governing authorities, I didn't talk about a lot. I think at some level, the federal jurisdiction in 91-24 supports that. There are some complexities there. I did reference 22.3 as where the federal government is empowering Indigenous communities' laws to prevail over provincial law, and there are some complexities there, I think. The law in general engages in a recognition of Section 35 rights in a way that goes beyond what the courts have said. The Supreme Court of Canada has not recognized Section 35 to contain self-government rights. The Pamajuan decision in 1997 is the last authority on this, and it sometimes gets left aside. The federal government has recognized self-government rights, but the courts at the highest levels have not tended to do so, but that position could change. I think there are some Section 35 rights in the child welfare context, certainly, but the federal government putting that in legislation as a recognition by it of the contents of Section 35 probably can't bind the provinces on that. It's something that would have to go to the courts. So it may be delegating powers that Indigenous governments already have. To the extent does that, there's no problem. Where it's going farther, it runs into some difficulties, I think, in terms of the relationship between federal and provincial law that would get really complicated yet.
You're very close to the end. We'll give you a short question if you wish.
So I think, is there ways that you believe that we could craft amendments that would still meet the very important goals of the Indigenous communities across this country, and not end up being challenged through? I guess you can never avoid challenges through the court systems.
Well, one can never avoid challenges entirely, but some of the things that strike me as possible amendments, if one's working with the bill sort of much as is, although there have obviously been other critiques of it that could call for other reshaping. But thinking of it from as is, I would restrict Section 7 so that the bill is purporting to bind only the federal crown and isn't trying to say something about the provincial crowns, because that's not a matter for the federal government to decide. So an amendment to Section 7. Sections 10 through 17, I think, should be amended in some way to operate subject to agreement with individual provinces that I hope they would offer, but otherwise, to the extent that they're applying off reserve, I think they're running into provincial jurisdiction. So an amendment could be crafted to require provincial agreement to the off reserve application. And maybe something of the same sort in respect of Section 22 sub 3, because again, once it's applying off reserve, there's some difficulties there. I'll stop.
I know you're a constitutional lawyer. It's difficult to stop. Okay. There's a lot of angles. I don't mean to take light of that. Thank you, Kathy. We're moving the question to MP Rachel Blaney.
Thank you all for being here today. I think one of the major discussions underlying all of this is intent versus impact, and I think that's so important that we bring that up again and again. Cindy Blackstock was here just earlier this week, and she spoke about having funding principles in this legislation actually put in the legislations. She suggested that they be based on the Human Rights Tribunal that we all know is still in contention with this government. You also, so I'm going to talk to Hadley and Naomi first. You spoke about funding. Can you speak to that and what you think needs to be actually in the legislation to make sure there's at least principles of funding?
Absolutely. So as I mentioned, I believe that Dr. Blackstock has had a black line version that she was circulating with amendments, and I do support those.
Cindy Blackstock's black line version is 8 documents, and it's in translation. It will come to committee members when it's done.
So the main things that I've seen on that draft that I agree with is that there's actually, it confirms in the preamble that it's an actual commitment, not just a recognition. And it's funny because your language bill actually has a commitment to equitable, sustainable funding, and I think there should be the same commitment here. And then in the, I believe it's in section 20, for your notes, basically, it is drafted such that it does still permit fiscal discussions to happen in the context of these cooperative or collaborative agreements. However, the buck stops. There's a provision that says, notwithstanding anything else in this Act, and irrespective of whether an Indigenous governing body has entered a coordination agreement, the minister at all times shall fund the costs associated with child welfare services. And it sets out various areas. It's the actual delivery of services. It's becoming self-governing, so developing to have that capacity, and then the actual self-governing. So I would agree that those are fundamental to actually this being at all effective.
Okay. So one of the things that concerns me is this is a framework piece of legislation, and all of you at the table here spoke about certain issues of language and how it's used, things like the best interest of the child and the concern about it being hollow without substantial support and funding. So can you just speak, because I think that's important, because I think sometimes what I hear people say is, well, don't worry about that, Indigenous communities will be making the legislation, but this is the framework legislation around it. So why is that so important that that be worded appropriately? I hope that makes sense.
Because, I'll try and then, because it needs to be set out in law. When something is not set out in law, there is uncertainty, and the whole system, the way child welfare has worked since the mid-60s, nothing is set out in law. There's nothing in the Indian Act about it. It leads to all kinds of uncertainty. It allows for this hot potato issue. So having framework legislation has to set out the bare minimum of content in terms of Indigenous people's rights, but also government's obligations. Because if you don't set them out in legislation, it just leads to fighting and uncertainty and litigation, and in this particular context, Indigenous children, bearing the brunt of it. So that is why it's so key to get those really firm, very funding, accountability, jurisdiction, but it's so key to have those set out in law, because that governs entirely how people deal with each other.
Thank you.
What I would add is courts will be called to interpret this, and they'll be looking at what came before. So having that language that's clear so they can see they're supposed to be doing something different here is going to be crucial when there's disagreement.
Okay. Is there anything you would like to add to Melanie?
I support what they've already presented.
Okay, so the other thing that you talked about was accountability, and I just want to get really clear on the record what needs to be in this legislation so that we make sure accountability is key. Because I can tell you, I am about 20 children's cultural care plan. I don't have a time in my life for 20 children to be their cultural care plan. So when I look at how Indigenous children are treated when they put into care, and they bring me and my husband in and they say, you guys are now responsible for that, without any sort of support, I know children are paying. They're paying and they're paying again. So what do we need in terms of accountability so that we can call everybody to account and stop seeing that hot potato of passing children around?
I would have three, which is a recognition of federal obligation to fund in this area. That's one. Two is sort of related to it, to the level specified in the Caring Society decision, substantive equality, services and funding that meets their needs and circumstances consistent with the cultural, geographical, and historical circumstance of Indigenous people. And my third one is that there needs to be a dispute resolution mechanism that is effective, meaning binding decisions. That's accountability to me.
Okay, good. The other thing that I heard was clarity for frontline workers so that they actually know how to implement what needs to happen. So how can we make sure that this bill is strong enough to make sure that frontline workers are actually seeing that being implemented? And what needs to be tied to that in terms of funding and support for training and so forth?
I think drawing on the American experience can be helpful here. I think certainly having support for interpreting and understanding this for workers, for Indigenous peoples as well, will be very important.
And this was brought up again and again, best interest of the child. How do we define that? So what is the gap, and what do we need to put in there to make sure it's defined well?
I'm going to tell you, Ashley, if you want to talk about the best interests of the child, I think you need to work with the Indigenous communities to help identify what that is in relationship to who they are, because I think quite often the best interests of child have been based on a system that wasn't our system, and what might have been important in a European kind of process may not be what's the most culturally relevant, important thing to the children. I mean, having healthy, happy children is what we all want, ideally, but in what system that we're assessing some of that needs to really be considered. And I think that working with our Indigenous governments and our Indigenous communities is going to be the best place to put that forward, so that it isn't a system that's just fluffy words and doesn't have really any impact.
So I agree with that, but how do we make sure this framework has strong enough language to support the language that every Indigenous group puts together for their own legislation? Is there an answer?
Okay. In the black line version, there's a suggestion to allow for those laws. I think also the onus on who's needing to address it and having impermissible reasoning, stopping some of the binding precedent.
Thank you. Now moves to MP Will Amos.
Thank you, Chair. Thank you to our witnesses, both here and on video. I wanted to offer our witnesses, Ms. Metallic and Friedland, the opportunity to respond on the division of powers question to Professor Newman. I'm interested in this topic. I know that there's been a charter statement tabled in the House, but that doesn't go to division of powers. So I think it would be valuable to have a further discussion. I don't think, my initial thought would be that I don't think it is unprecedented that that federal legislation references the provinces. So I don't think that is in and of itself untoward. But I can also appreciate that we're in a unique circumstance where we're changing the status quo and we're enabling through framework legislation an approach to child welfare that is going to empower those that have the most at risk, the most to lose, and the most to gain out of this set of circumstances. So over to you, Ms. Metallic and Ms. Freeland.
Thank you very much. I'm going to say to that point, I thank you for the opportunity to speak to this particular issue. I do not share the concerns of Professor Newman with respect on this issue whatsoever. I think what he's primarily focused on is the fact that the federal government is purporting to create some national standards that would be paramount over provincial laws. And so the question is, can the federal government, as a matter of constitutional jurisdiction under 9124, pass laws with respect to Indigenous child welfare? Now, it's not the case to say that there's certainly places where the feds have already legislated over areas that tend to often be viewed as maybe historically provincial. So there's provisions on wills and estates in the Indian Act. That's tended to be viewed as provincial. There's been provisions on education. That tends to be viewed as provincial. Family disputes on reserve. That's also been viewed to be provincial. But you know, so the way 9124 is structured, it says Indians as one area and lands reserved for Indians. So lands reserved for Indians is the territorial on reserve Indian lands, and we can get into broader areas of land. But then we still have the jurisdiction over Indians, and that is not bounded by territoriality, and that has to be kept in mind. Peter Hogg has written about this, Professor Peter Hogg, and so the jurisdiction over Indians, first of all, has been found in the 2016 Daniels case to extend not just to Indians, as well as Inuit, found in the Re-Eskimo case from 1939, but to also extend to non-status Indians and Métis, which certainly live off reserve. So it's not just the jurisdiction doesn't extend that far. Now, to the question of whether jurisdiction can extend to areas classically viewed as provincial, Peter Hogg's argument has been that, of course it does, because why would we have Section 9124 without it? If the feds could otherwise pass laws that overlap on provincial areas that under its other jurisdictional power, it wouldn't need 9124. So that's why 9124 is there, to allow the federal government to pass specific laws that ameliorate or are specific to the situation of Indigenous people. So there's clear jurisdiction or authority study on that, at least from one of the foremost constitutional law lawyers. Also, Sebastian Gramont, who produced a paper arguing for legislation in this area, also agrees with Professor Gramont. So you can go look at his writing as well, seeing that there is no problem with the federal government having producing national standards, and there's such a need for them. And I think the last point on this is that, you know, it's kind of ironic given the history of jurisdictional neglect. The provinces are not clamoring for jurisdiction in this area. They never have wanted it. They want you to have it. They've never wanted it. So I really don't think that you really have a massive risk of the federal government or the provincial governments beating down your door saying, how dare you take Indigenous child welfare jurisdiction away from us? Did you want to?
Thank you for those comments, and I think that it's, it's clear, and it goes without saying, that the federal government or the government of Canada wouldn't be seeking to trench on provincial jurisdiction. As a lawyer and former law prof myself, I can appreciate that there are always going to be gray areas. There will, particularly when you're in a new an area of new legislative. A new area of legislation where the federal government has traditionally not been engaged.
Right.
But I just wonder, Professor Newman, is it your sense that there is a real risk that there will be provincial governments seeking to bring cases on the division of powers over this issue, or is it? I'm trying to get a sense of if this is a very real risk or if this is a more of an academic and theoretical risk.
Well, I haven't tried to carry out a full survey of the provinces on this. I know at least one provincial government has already raised concerns with the federal government over the legislation and has asked for more dialogue around the federal-provincial interaction in relation to this legislation. So if that isn't resolved in a cooperative way, I think there probably is a real risk of facing issues down the road. I agree with the point that was made that we haven't seen provinces clamoring for jurisdiction in this area, and we may not see that still. But to the extent that there's an expansion of federal involvement, especially off reserve, I think provinces are going to have something to say about that. And as I say, at least one province has already raised concerns with the federal government over these issues. I would just briefly add, if I might respond to the last comment, that there are, of course, some mixed views on the division of powers questions generally. There are some very contested points. The scope of 9124 has been very little tested out. Of course, the federal government can set national standards when it actually has jurisdiction in an area. But when it doesn't have jurisdiction, it can't set national standards. And to the extent that it purports to use 9124 to legislate over Indigenous children generally, it's very much into an area where there's room to talk about, is that in pith and substance about a 9124 matter or a matter within one of the heads of provincial power. And so I don't make the claim that every part of this bill is going to fall, but I think there are real division of powers questions there. And I'm very concerned to hear that there was only a 5-minute discussion with the Department of Justice on those. They certainly would have background material that I think it would be proper to ask them to share further in order to get to their view more clearly on what the state of affairs is and to be able to analyze that.
Well, thank you very much for all of your presentations, your insights and your guidance, your recommendations, because we have now used up our hour allocation. And you're an important piece of a dialogue on the bill, part of the official public record, and we take your comments very seriously and your submissions. Merci, Miigwech. Thank you.